Kyle Rittenhouse collapses after hearing the not guilty verdicts in this homicide trial. Not guilty on all charges. Joining us now, defense attorney Michael Hart with Hart Powell SC. Thanks for joining us. Your reaction to that verdict today?
It's always a relief, right? Trust me, I've stood there next to clients and takes your breath away, that's for sure. Once the issue of self-defense was raised, it was going to be a tall order for the state to disprove beyond a reasonable doubt that Mr. Rittenhouse didn't act in self-defense. That's the crux of it.
The defense says prosecutors rushed to file charges after the shooting. Was the prosecution's fatal flaw they filed the wrong charges?
I don't know about that. I mean, this is a homicide case, right? When they dismissed those misdemeanors, people were critical of the state for bringing those in the first place. Those might have saved, my thinking at the time was those may have saved Mr. Rittenhouse to the extent that they wanted to compromise. The bigger concern was that they would settle on one of the lesser included, and then he's really got a problem. No, I think they brought the right charges. I think the prosecution issued the case as they would in the ordinary course, and the jury served its function, and the system worked.
I want to ask you about the risky move to put Rittenhouse on the stands, because Mark Richards had some interesting comments today, Rittenhouse's attorney. He said they held a mock trial to prepare. That happens sometimes, especially in big trials. And it was based off the reaction of the mock jury that they decided to put Rittenhouse on the stand. Now, here's the quote from the attorney saying, "In Wisconsin, if you don't put a client on the stand, you're going to lose." You're a defense attorney. Do you agree?
Yeah, if I can keep my client off the stand, I do. And they took some criticism, I think, because the trial was going well after the state rested its case. And there was some conventional wisdom that said you don't need to expose Mr. Rittenhouse to cross-examination where the trial sits at the moment. But in order to get the self-defense instruction, I think Mr. Rittenhouse had to testify. It helps to be able to have those resources with jury consultants and mock juries. But at the end of the day, the reason I suspect that Mr. Richards and Mr. Shirapasi put Rittenhouse on the stand was so that they could get before the jury the issue of self-defense and ultimately request that instruction from the court, which led to the 5 acquittal.
We heard from lots of witnesses, but was it that moment where he went on the stand and was cross-examined for hours and really stood his ground, was the pivotal moment of this case?
It was important, right? Juries want to hear from a defendant more so than defense lawyers want their defendant to be heard from. And so I thought Rittenhouse did a credible job. I don't think that made or broke the case. The self-defense issue and the facts of the self-defense from his mouth were the important thing that got the self-defense instruction. The other witnesses were pretty good for the state, for the defense too, I gotta say.
Let's talk about the judge, because a lot of people thought some of the things that were brought up in this trial before, what he allowed, what he didn't allow, some of the comments allowing Kyle Rittenhouse to pick out the alternates himself was different. They'd never seen anything besides that. Mark Richards today says he thought they got a fair trial because of the judge. Your thought on now that the case has concluded, how he did?
Well, the judge is unorthodox. He's always been unorthodox. The Rittenhouse picking the names out of the box is no great shakes. I don't really care about that. Allowing the jury to take home an instruction sheet, now that is bizarre, to be kind. I don't know. I don't think the judge made much of a difference in the case. I think he let these lawyers try it. It was appropriate for him to take those mistrial motions under advisement. It wasn't criticism that he didn't rule on those motions until after a verdict is a lot of nothing, frankly.
Do you think the jurors, this is my last question here, do you think the jurors that got to take home those jury instructions made the difference here? They're doing some sort of homework at home?
Well, it's always the fear and concern. That's why we don't do it. Juries should deliberate in private without outside influence. They could always talk to people at home and disregard the judge's instructions, whether they have the written instructions with them or not. It just was very, very odd. something I've never seen in over 30 years.
We'll have to wait and see if the jury talks and tells us what was the make or break moment for them. Michael Hart, defense attorney, we appreciate you joining us.
Anytime, Ben. Thank you.